We are here this morning in the case of Fields versus elected officials retirement plan. Each side will have 20 minutes for your argument. Counsel for appellant, if you want to reserve time, you'll need to do that yourself by watching the clock. These proceedings are being audio and video recorded. I think they're actually being live streamed on YouTube now. And we would appreciate it if you would identify yourself and your client the first time you come to the podium. We have read the briefs in this matter. We've conferenced the case. We're familiar with the facts. And with that, counsel, you may proceed.
Thank you, Your Honor. May it please the court. I am Andrew Pappas, appearing on behalf of defendant appellant, the state of Arizona, and I would like to reserve 5 minutes for rebuttal. The Superior Court awarded the plaintiffs $43,000 more in attorney fees than the plaintiffs paid or agreed to pay their attorneys. Section 12-341-01, the statute under which fees were awarded, forbids that result. We know that first by looking at the text of the statute. Section 12-341-01 allows discretionary attorney fee awards in contested actions arising out of a contract and imposes two distinct and independent requirements. First, the fee award must be reasonable. And second, the award may not exceed the amount paid or agreed to be paid.
Counsel, I think you had said that the plaintiffs hadn't agreed to pay their attorneys. Is that accurate?
That's correct, Your Honor. They haven't agreed to pay their attorneys within the meaning of the statute. Okay,
well, let's real quick look at the fee agreement. And if I can just, I don't have the actual agreement in front of me, but there's a sentence that has the second half of the sentence says, clients shall petition the court for fees and costs. Do you see that?
Yes.
And then if you go down a few paragraphs, clients agree to pay those fees and costs over to their attorneys or to attorneys. How is that consistent with your argument?
Well, Your Honor, the agreement that the plaintiffs entered into with their counsel does not impose on the plaintiffs the kind of genuine financial obligation that this court's case law requires. That requirement comes from the statute. It comes from Lisa versus Strum. And the Supreme Court in Sparks made clear what that kind of genuine financial obligation looks like. It is payment out of the plaintiff's or the litigant's own pocket to offset the attorney fees incurred. Now, here, there is nothing to offset because there were never any attorney fees incurred.
I have to admit, I'm of two minds on this, and I want to give you two viewpoints. See if you can explain them away. Viewpoint number one, I think, is that our case law makes pretty clear that 12-340-101 does not prohibit recovery in contingent fee cases, correct?
Yes.
You would agree with that?
I would.
Okay. And then that becomes awkward in this case, or in a lot of cases like it, because that effectively reads into the statute a damage remedy component that isn't there. So if we agree that it allows for contingency fee cases, but we say it only allows for contingency fee agreements in cases for damages, we've just imposed a limitation that the statute doesn't write. But on the other hand, we have fairly well established practice under the statute saying you can't keep two sets of books. If you're a lawyer, you can't say my fee for you, client, is $5,000, but my fee for the other side is $400 an hour. How do you reconcile either of those views with the text of the statute?
Well, the text of the statute makes clear what its purpose is. It is to mitigate the burden of the expense of litigation.
Isn't that exactly what that fee award would do in this case?
Not at all, because the plaintiffs in this case bear no burden whatsoever of the expense of litigation.
Well, let's back up to my question, though. If we start with viewpoint number one, the idea that contingency fee agreements are okay, even though if at that point, the lawyer is bearing all the risk. How do you get around the implicit amendment to the statute that says only in cases for money damages?
Well, I don't think it implicitly amends the statute, and I don't think it's true that in a contingency fee case, the lawyer bears all the risk. The client bears some of the risk that if the client is successful, something will come out of his pocket in order to pay the attorneys.
Well, something that was never in his pocket will be diverted, and that's basically the case here, isn't it?
No, it's not. It's something that would otherwise belong to the client in a real sense. In this case,
So in a real sense, the normal recovery path of 340-101 isn't money in a real sense?
Well, the normal path under 340-101 says that if you obtain a judgment in your favor, if you acquire something and you pay a portion out of it, or you pay an hourly rate, let's say, that, of course, the 340-101 is not limited to contingent fees. But what we know from the case law, and what we know just sort of as a matter of common sense and common practice, is that attorney fees are meant to make parties whole. They are not meant to create windfalls.
That's actually not what the statute says. The statute, you read the part in the statute that says what they're meant to do, and that they're meant to mitigate the expense and burden of litigation, not make the plaintiff whole.
That's correct, although this court's case law makes clear that it is meant to make the party whole. This is Lisa versus Strum. It's also, I think, what was underlying the Supreme Court's decision in Sparks.
Who wins, the statute or the case law? It seems to me the statute is the law. Any interpretations we have, we get a chance to revisit here today. But unless you can tie the result you seek to the text of the statute, I don't see how we get there.
Well, I think we tie it in two ways. First, again, the statute says it intends to mitigate the expense, the burden of litigation. We know that the purpose is not to make attorneys whole, it is to make clients whole. The plaintiffs in this case were never anything less than whole because they would never have to come out of pocket a dime. What's happening in this case is that the state is getting stuck with a bill that nobody would otherwise have to pay.
So if an attorney agrees to take a case and charges a rate and then just decides at the end, I know you can't afford to pay this, I'm not going to send you, I'm not going to foreclose or on your house or otherwise try to collect this debt in some way that you owe me. They just make that decision after. There's been a contract that says you're going to have to pay attorney's fees of $40,000. And the attorney just decides after the fact, well, if we don't win, I'm not going to collect. Is there that much of a difference? We're going after it. They were the prevailing party. What difference does that agreement, how does that affect the party that owes, that's on the hook for the fees? There is an agreement that says I'm going to pay, or the client's going to pay $40,000. We're going to want to go into it. Well, is the lawyer really going to collect that amount if you don't pay it? Under that scenario, you would agree that you have to pay it under the statute.
Well, I think it's a little bit different because, again, at least there is some ex ante risk for the client, which the client can factor into its calculus about whether to file suit. And we know under Hall versus Reed, that is one of the purposes of the statute, is to encourage parties to think twice before they sue. But in that hypothetical that Your Honor posited, if there were no attorney fee award paid, it would be perverse to allow the litigant to then go and recover attorney fees that the litigant never paid. Again, if the purpose of an attorney fee award is to make parties whole.
I'm saying the client is on the hook for $40,000. Whether no one is actually going out and trying to collect the $40,000.
I think if the lawyer discharged the client's debt, for the client to then come to the court and say...
Well, no, the client's going to the court beforehand.
First. So
right, I'm saying a year down the road, the lawyer is going to discharge the debt. How does that...
Or the lawyer is going to discharge the debt only if the lawyer doesn't prevail, and that becomes irrelevant because if we're asking for 12341 fees, the lawyer has prevailed.
Well, I mean, I suppose we're getting a bit far afield from the scenario here where, again, the clients agreed to pay nothing.
We still haven't gotten to the text of the statute.
This text of the statute says that it cannot exceed the amount paid or agreed to be paid. I cannot imagine what that statute...
You have agreed to pay an amount, whatever the court determines to be reasonable, based on the hourly rate and the time spent.
The problem is, if that interpretation of the statute prevails, and that it is impossible for an award in a case like this to ever exceed the statutory cap, because the amount of the award will always be the amount of fees paid or agreed to be paid.
And
Does
not
it
exceeding the
itself to be reasonable?
statutory cap is what the statute requires.
I'm
So
sorry.
not exceeding the statutory cap is what the statute requires, so where's the problem?
The problem is that it effectively nullifies the cap because it simply says that the limit is simply whatever is agreed to be paid. I can't imagine why the legislature would impose a statutory cap like that if it weren't intending to force litigants to think about what kind of risk they're incurring at the outset.
Well, there's an easy reason why the legislature would impose a cap like that, and that's to prevent cronyism among the bench and bar.
And I think also to prevent windfalls to litigants, which is precisely what is happening.
But
Let-
doesn't
let-
it prevent, sorry, go ahead.
Let's talk about this fee agreement. We keep saying on the hook. Would you concede that the clients here, if they didn't move, if they prevailed, and they didn't move the court for fees, would be in breach of that fee agreement?
I suppose that if they did not comply with their obligation to petition for fees, that is correct.
Right, so that was
Although the fee agreement, forgive me, Your Honor, the fee agreement also says that no fee shall be payable except out of any recovery under an attorney fee award.
No,
And
understood. Okay, so we got that first part. So there's a contractual obligation on the hook to pursue and ask the court for fees if you get a W, okay? And so then we have money. Would the client be in breach of the fee agreement if they didn't pay that money to the attorney?
Quite possibly, yes, Your Honor. I think that is likely.
So
But again,
how is this not on the hook? It seems to me like there's two hooks. That one, you have to ask the court for fees if we win, and two, you have to pay us. And if either of those are not met, you are on the hook. You've breached the contract.
because, again, Your Honor, it is not the kind of out-of-pocket obligation. Again, I mean, I think we have to go back to the Supreme Court's decision in Sparks, which the plaintiffs themselves say is controlling and dispositive of the case. The Supreme Court there said that the reason why a contingent fee agreement can support an award under 12-340-101 is because it means that the client has to pay something out of pocket, and because the attorney fee award offsets the expense of litigation. Again, here there is nothing to offset.
What if the agreement here said, I'll pay you 200% of whatever the court awards? Would that be okay?
I will pay you No, I don't
200%.
think
If the
so.
court awards 43,000, I'm going to pay you 86.
That perhaps.
Okay.
That may.
So if that's okay, then you know, because we're running out of time, I'll go down the slippery slope quickly. What if it's whatever the court awards plus $1? Then
Well, then
that
I
would
think-
have to be okay.
But I think the amount paid or agreed to be paid is $1. The amount paid or agreed to be paid is, again, the only way to impose this statutory cap and the only way to allow litigants to assess at the outset what the actual risks of litigation are, and we know that those are the purposes of the statute, is to impose the cap by saying whatever you paid or agreed to be paid, you can get, or agreed to pay, you can get back in attorney's fees and no more. You know, again, I would go back to Lisa. Lisa says fee awards are meant to make a party whole for costs incurred for an attorney's services, not to create, quote, windfalls to persons who have spent no money and incurred no debt
Why
for
is it a
legal
windfall?
representation.
Why is it a windfall for the party that has to turn that money over to someone who's done the work and there's been a determination that it's reasonable? How is that a windfall?
Well, it's a windfall both to the litigant who paid nothing, and as plaintiffs
Oh,
have
wait,
pointed out, the
the
attorney...
plaintiff doesn't get anything out of that fee. That's just a reasonable fee that's been determined by the court. So I'm puzzled that that's a windfall to the...
First of all, reasonableness is an independent inquiry under the statute. We know that from
Right,
Lisa.
but we're going to
Second-
assume that what's awarded is reasonable. How does that end up being a windfall to the client?
As the plaintiffs have pointed out, an attorney fee award is vested in the litigant, not in the lawyers. So it's $43,000 that gets vested in the litigant. That is a $43,000
But you're saying
windfall.
they don't have an obligation to turn that over?
They
There's
do
a
have a-
specific contract here that says you have to turn that over. How does that result in a windfall?
Your Honor, on the one hand, it shows that it's a windfall because the money is being invested in the litigant. On the other hand, it shows that they've agreed to pay nothing out of their own pockets because they're simply turning the award over to their lawyers.
But you're losing me on the windfall aspect. A windfall means I get something that I'm really not entitled to, or I suddenly have this pot of money. I don't have it.
I think the windfall here works both ways. The litigants are getting an award that is technically vested in them, which they then have to turn over. The lawyers are getting...
Isn't that statement that you just made the answer to Judge Weinzweig's question and the death knell of your position? They agreed to pay.
No, Your Honor, they did not agree to pay within the meaning of the statute. Again, I think under this court's, first of all, under the statutory text...
Is there a definition of pay in the statute?
Or does it say agreed to pay, bracket, out of their own pocket, end bracket, period? Or does it just say agreed to pay?
It says agreed to pay. The
And then
Supreme Court has definitively construed that language as requiring an out-of-pocket obligation. This court is free to revisit its own case law. It is not free to revisit the Supreme Court's case law in
But
Sparks.
even out of pocket, we have those two contractual requirements. You will ask the court for money, and you will pay the money. Seemingly, at some point, that money is in their pocket.
And to take that one step further, isn't the right to receive the payment? If the court awards $40,000 in attorney's fees, to the plaintiff, doesn't the defendant have to pay that money to the plaintiff, not to the law firm?
Well,
and then the plaintiff has agreed to pay it to the lawyer.
In fact, the plaintiff's contingent fee agreement says if it's paid by a joint check, you can just endorse that right over to the lawyers.
That's not this case.
Yeah, in fact, it is this case.
If it's paid by a joint check?
This is in the fee agreement. If any recovery is paid by a joint check to attorneys and client shall endorse such check over to attorneys.
Right, but that doesn't go to the core of my question, which is who has the right to recovery? The right belongs to the party, not to the lawyer, and the party has committed to forego its entire value in that right by giving it to the lawyer.
The party has agreed to turn over fees to pay a bill that no one else would have ever had to pay. I see that my time is done. If I may reserve it for rebuttal.
Please do.
Thank you.
Thank you.
Good morning, Your Honors. Colin Campbell from Osborne Maladon, representing Judges Field and Judge Porter. Judges, I think we said pretty much what we wanted to say in our brief. I think I'd just like to respond to a few points. First of all, this is a pension plan case. And like pension plan cases, the relief we're seeking, that Judges Porter and Fields were seeking, was equitable relief, an injunction and a declaratory judgment. So at the end of the day, there's no pot of money in the sense of a traditional contingency. We get a third of any recovery. Therefore, the fee agreement in this case, which is set out on page 9 of our brief, the entire section 2, was drafted in accordance with the prevailing case law. It said specifically that the client was responsible for the hourly rate and the regular hourly fees of the firm, and they undertook that responsibility. It also said they had the responsibility to petition for fees pursuant to any fee-shifting statute that applied. And Hall made clear that 12-341-01 applies to pension plan cases. And then it said that the contingent part of it was we limited our fee to the event that we prevailed and to the event it was granted by the court. And that's exactly what took place in this case.
How then do you distinguish that from the generally prohibited practice of having a side agreement with the client and then filing a full freight fee application?
Judge, we have no side agreement with our client.
No, but I mean, think about it. This comes up fairly frequently in family court where you have a flat fee agreement coupled with an hourly rate that will be used in a fee application, and that's at least a disfavored, if not prohibited, practice. Would you agree with that?
I would think if you were dealing with the court, you had to be honest what your fee agreement was, and you wouldn't have a hidden fee agreement that you would keep from the court.
Okay, but and I would agree that honesty with the court is a critical component, but is there a meaningful legal or economic difference between the arrangement where you say, I've got a flat fee for the client, they've paid me my few $1,000s, but I may file a fee app for $150,000 at the end of this case because I've been racking up all these hours? Is there any real economic or legal difference between that disfavored arrangement and yours?
Well, that arrangement seems entirely different to me. The lawyer has agreed to a flat fee, and really, under 12-341-01, shouldn't seek more than that. In this particular case, as has come out in the questioning, the ability to petition for fees belongs to the client. So the client has the right to the fees. The client petitions the fees, gets what is awarded by the court, and we agree that we will take that as a contingency with respect to our fee. There's no hidden fees, there's no two different charges, it's a very different situation.
I thought I heard you say that it mattered that this was a pension fund case.
Well,
So
yes,
is that accurate, or what? I mean, let's say you had some large-scale investment fraud where you had a class action on behalf of investors, yet we have the same fee agreement. Is that a different result?
well, I don't think, if you're dealing with contingencies, I don't think you should distinguish between contingencies that has a money pot of damages and contingencies that are seeking fee shifting. That's a distinction that is nowhere in the statute. The reason I brought up this as a pension case is that, this is real, we haven't talked about the facts of the case because the petitioners won, but the legislature had capped employee contributions, which was going to result in the complete defunding of the pension plan in 10 years. Now, for any individual pensioner, the cost of bringing that particular case is really prohibitive. I mean, this pension plan includes people who are clerks of the court, who are county treasurers, who may have been, just in county office for a couple of years. And even though the costs of this case were modest, $65,000, I think is a pretty modest fee for going all the way through an injunction. Most people in the plan could not afford an attorney to bring this case. It would be more than what they would collect an entire year from their pension. So the purpose of the statute to mitigate the costs of litigation are clearly enhanced here and furthered here by allowing this type of contingent fee.
Can you cite me to a case that interprets this statute on similar facts that would either be binding or persuasive, or is this an issue of first impression?
Well, we have the Moat case, which is a lemon law statute case, and it deals with the same issue. And even they say for the court to reach the result they want in this case, you have to overturn Moat, which is a 2002 case. I would point out that if the legislature thought there was something egregious about that case under the lemon law, they have done nothing to amend it since that time. And this is a statutory right to fees that we're dealing with. So although Moat is the lemon law, it deals with the identical same issue and reaches the result that supports us in this case.
Is the lemon law, is it a 12-341, or does it have its own fee shift?
It has its own fee shift, but the same issue was presented. I can't remember if it was the wholesale auto dealer or the automobile manufacturer argued that we don't have to pay fees because there was no obligation to pay fees on the exact same argument, that it was a fee shift and the lawyer was going to take the fee shift and therefore.
There's no difference in the language of the statute.
Right.
It seemed like there was a study.
Yeah, no, I think I think the argument in Moat was that implied in the statute was a financial obligation to pay fees. So they dealt with the issue that they were arguing they had to pay the fees out of pocket, but reached the result that we think you should reach in this particular case. Now, certainly on 12-341, I mean, if you look at it broadly, I mean, in Arnold, although they end up using the private attorney general doctrine, they say, and I think it's in dicta, that a pro bono attorney could use 12-341-01, that it would be unjust and inequitable not to allow them to do that. If you look at all the different variations in which 12-341 has come up to the court, and we cite a lot of them in our brief, the court has always sustained the ability, in order to mitigate litigation, to reach out and get those fees.
Well, I agree. It makes complete sense, particularly in the context of pro bono counsel. But just going to the specific language of subsection B, what in your view is the point of B, subsection B? It becomes a little bit circular to say you can only award the amount that you've agreed to pay, but you really haven't agreed to pay anything unless the amount gets awarded.
Well, I think it would stop and, let's say you have an agreement with your client that I'm going to charge you my regular hourly rates, just a typical lodestar type case. But if we win, I'm going to go in and ask for 3 times my rates. Then I think that would be a situation where the statute would cap you. Now,
And that would essentially be consistent, was it the Lacer case, where if the government prevails, the government can only collect the amount that they're actually paying to the government lawyer, factoring in whatever
Right.
overhead or however that works?
I think that's the Navajo County case where they say you can't charge regular hourly rates for your public lawyer.
Right.
You have to look at what they're actually paid plus attribute some overhead to it. So Judge, really at the end of the day, I think if you look at the entirety of the case law, I think we have to prevail on this particular case. You might ask yourself, and I'll say this in closing, why are we here on a $43,000 attorney's fee award? I imagine this is probably one of the smaller awards you've seen. And I think the reason we're here is the state does not want litigants to be able to sue the pension plan and seek equitable and injunctive relief by making the cost of it prohibitive.
Let me ask you, you'd made an argument in your brief that subsection A is sort of the gatekeeper, the threshold issue. You either, good news, you qualified or you haven't qualified for fees. And that B is only once you get in that room and you sit down and what is the amount? What is the number? Was that your argument? And how does that impact the narrative or the facts here?
Well, all B is it's a statutory cap on what the client agrees to pay. In this case, the client agreed to go in on a fee-shifting statute, would seek all of our fees, would take what was reasonable that the court granted, and then agreed to pay it over to us. So the statutory cap is simply that in this particular case.
And so does A stand alone, untethered to anything else, and your client either qualifies or doesn't qualify based on A, and it's only at B that we concern ourselves with agreed to or
I think A stands for itself. I mean, it brings in all those issues of, the Warner case and reasonableness and every prevailing party and all of that. None of that's at issue in this particular case. They haven't raised an issue as to any of that.
And could I go back to what you said a few minutes ago? B, you're suggesting, is designed to prevent you from saying, I'm going to charge you $300 an hour, but when we go into court, I'm going to ask for $600 an hour.
Yeah, it would certainly prevent the.
But why is that much different than saying, okay, so if you say, well, I'm going to charge you $10 an hour, but if we go into court, I'm going to ask for the prevailing amount, just a reasonable attorney's fees of $200 an hour. In that circumstance, would you say the court is limited to awarding $10 an hour?
I'm not sure I would, because we have that case that we cited in our brief where someone had a fee agreement saying we'll take $400 an hour or a certain percentage of the award, whichever is greater. So I think it would depend on how the fee agreement was drafted. I think you probably
But
could
if you have an agreement that's completely under market rate and you're just saying, I'm willing to charge you $100 an hour, but if we're successful, I want to ask the court for what the reasonable rate, which would be $200 an hour. I'm just pulling numbers out of thin air, but in that circumstance, would it be limited to $100 an hour, or would you be able to ask for $200?
Well, it would, the permutations you could do on fee agreements are infinite, I've discovered in the last 13 years. But if the agreement was you pay me $10 an hour because I want to have some compensation as I'm going forward, so I'm not bearing the whole thing. But we agree that this is a fee shifting case, and I can ask you to go into court and get all of my reasonable hourly rates. I think that would be permissible. And there are mixed flat fee contingency agreements out there that we do all the time. So we want the client to bear some costs, but we're going to go into court and seek more.
Is there any relevance to this being a class action or punitive or Rule 23 case?
Well, actually, it didn't end up being a class action. It started out as a class action, and then the state and the EORP stipulated whatever relief would apply to everyone. So there was no class actually certified. And I don't think the class action aspect of it by itself changes anything, though. I mean, the class action rules don't have a fee shift with respect to them. They present the same damage versus equitable remedies. You can have class actions where you get a common fund and then you seek a contingency fee on the common fund. But if you have a class action just seeking equitable relief, and that's sort of what happened in the Fields 1 case. It was an equitable and declaratory judgment action.
When we talk about all this action, public interest, none of that really has anything to do with the merits of this case, correct? I mean, it's atmosphere for reassuring ourselves that we're not committing some sort of insane policy mistake. But ultimately, there has to be one rule for every case.
Correct.
And so you're not asking us, I take it, to announce a rule for class action or public interest law.
We are not.
Okay.
We are not. This is a straight, Hall says 12341 applies to pension plan cases. This is a straight pension plan case. The parties prevailed. They moved for fees.
It wouldn't matter if this was a case over the validity of an arbitration clause for the sale of an air conditioner, right? I mean, isn't it the same
Any
thing?
case arising under contract should have the same rule.
Even if there's no prospect of monetary relief.
Correct. Thank you, Your Honor.
Thank you.
Counsel, could you address what happens where there's a pro bono attorney, and I guess the Arnold case in particular, and why we wouldn't want to encourage pro bono representation, and why the result you're proposing is consistent with encouraging pro bono representation?
Of course, Your Honor, the Arnold case involved an entirely different statute. It involved 12348. And that statute said you can't exceed the amount paid or agree to be paid unless a special factor is present. And in that case, the court found that there was a special factor present, and that was the existence of too few attorneys who could pursue that kind of case. So there was a statutory hook there. In fact, the Arnold court distinguished 1234101. The legislature has evinced no intent to incentivize litigation, pro bono or otherwise, under 1234101. And again, this isn't real pro bono litigation because the attorneys are expecting to be paid. If the legislature wanted to provide for pro bono contract cases, it could certainly do so.
How can you say they're expecting to be paid?
The attorneys have built into their agreement a provision that requires a fee application, and then they'll get paid out. They'll receive.
Which they know will be denied if they don't prevail. So they're not expecting to get paid. They're hoping to get paid, probably. I suppose if they're
yes.
really confident, they might expect to get paid, but they might lose. And in that case, they have no expectation.
Fair enough, Your Honor. But again, if the legislature wanted to incentivize pro bono litigation on contracts, it could certainly do so. It hasn't. What it said in its statute is that you can't exceed the amount paid or agreed to be paid.
Well, when you said they're expecting to be paid, that goes back for me to the statute, that it seems like there's an agreement to be paid. They're expecting to be paid, and the client's expecting to pay them.
The agreement is to turn over any attorney fee award. And again, I would just go back to Mr. Campbell says that the entirety of the case law supports this fee award. That simply is not true. The Lacer case, which he referenced, says that a fee award, Navajo County's fee award, had to be limited to Navajo County's actual hourly cost. Its actual hourly cost, irrespective of the reasonableness of the hourly fee requested.
But here we're limiting it to the reasonable costs of the attorneys who handled the case.
But
Why is that different?
the actual hourly cost to the plaintiffs is zero. The reason why the agreement that Your Honor posited, in which it's, we'll charge you $100 an hour, but if we prevail, we'll charge you $300 an hour. The reason why, Mr. Campbell is correct, the reason why that doesn't count is because the litigants in that case only agreed to pay $100 an hour. Here, the agreement basically is, we'll pay you $0 an hour. But if
So
you...
when you say the real actual, I think those are the two words you use, real actual.
Actual hourly cost.
Okay. When you get that fee award, and their clients have the fee award, let's say they have it in their pocket or they have it in their bank, at that point, isn't there a real, actual, whatever you want to call it, obligation?
But it's not the litigant's actual hourly cost. The litigant's actual hourly cost is zero. The actual, there are time records.
No, but at that point, they got money, right? You said the party, I think you said, has the interest of 12. So guess what? Big fee award for you.
But they can't have it
But you
both
can't
ways.
hold it under the terms of this fee contracts. That would seem to be real, actual.
They can't.
Well, finish your answer, but then
They can't have it both ways. They can't say on the one hand, this is our fees, so it belongs to us. But we're not incurring a $43,000 windfall by getting money to remunerate us for something we never had to pay in the first place. So this is
I
precisely.
think we've been down that road, but let me talk about 12348 and your attempt to distinguish it. Because it seems to me that the special factors you're talking about don't relate to exceeding the cost the litigant bore. The special factors create an exception to award a rate over $75 an hour. And that distinction has no bearing on this case.
I don't believe that's what the statutory language says. I don't think it is.
It says it will not exceed the amount the party has agreed to pay or a maximum amount of $75 per hour unless the court determines that an increase or a special factor, blah, blah, blah. So the special factor applies to that limitation that 341 doesn't even contain.
I don't think that's correct, Your Honor. I think the unless.
Well, I just read it to you. What's incorrect about it?
I think the unless language modifies everything that comes before it and not simply the $75 an hour thing. And I don't think that that's the holding of Arnold either. I don't think Arnold says that it only modifies the $75 prevailing rate. In any event,
but you didn't mention the $75 prevailing rate, and
because
it seems to me that that's a key difference. That's a textual difference that leaps out at the reader between this and 341.
Respectfully, Your Honor, I think that the key textual difference is that the legislature built in an exception to the statutory cap in that statute. It built in no such exception here, not for public interest litigation, not for pro bono cases, not for a special factor being present. It simply says the amount paid or agreed to be paid. I'd just like to correct one additional thing. And then
very briefly, Counselor.
With regard to the Moat case, Your Honor asked the question whether there's a difference in the language of the statute. There's a huge difference. The difference is the statute at issue there, the Lemon Law statute, does not include a cap on attorney fee awards at the amount paid or agreed to be paid. That is the operative language in 12-34101. It is the language that forbids the attorney fee award that the plaintiffs obtained. Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we will stand at recess.